Next matter is Nigel Ingersoll and Cassandra Ingersoll or Cassandra Varon, file 23-19438-DM. We have parties for that case. I do see Mr. Ingersoll. I do see Ms. Ingersoll as well. This looks like an order to show cause for contempt on custody and parenting time issue. Mr. Ingersoll, is this your
It is, Your Honor.
request? All right, why don't you go ahead and tell me what it is that you want and why you want it?
I would like some makeup time done in June. I came to court with you because I filed a motion to change my parenting time in custody. At that hearing, we established a visitation, and I made a trip to Tennessee to see my daughter. I called in the morning. Long story short, she dodged me on one of my days. I drove all the way to Tennessee, and she acts like she can just control how the court is dictating our situation. And I spent a lot of money to go down there, and I got dodged on my time, and I don't think that's cool. And I think that I'd like to give it the court's discretion to somehow make this up to me.
Well, tell me in a little more detail what time you spent with your child and what time specifically was kept from you.
Well, the first day I didn't get to see her at all, and then the second day, we did go to that cool little dance party in the caverns, which was super awesome. I've got I don't know, four, maybe 5 hours with my daughter, and then it ended in an argument, and my daughter's mom saying things in front of our daughter and her other daughter that she definitely should not have been saying in front of children. So she dictated my first day, and we agreed on it. And then I only got a few hours the second day. We agreed on a time, and I drove all the way to Tennessee. And it takes me 10 hours to get there, and I got 5 hours total.
So what happened on the first day that you didn't have any contact at all with your daughter?
She dodged my calls. They went out to the park, and they went out to eat. And because I stopped by the house, I drove by anyway, and there wasn't nobody there. I think Cassandra had to go to work, and whoever was with the kids who was gonna, they just decided they weren't gonna let me see my daughter. I had to make a stop, and yeah,
Did
there was
Ms. Ingersoll know? Did Ms. Ingersoll know that you were coming that day?
Absolutely. I called her at 7 o'clock in the morning. She answered, said that she'd call me when they get around. I sent her a text a little while later because I had a situation happening. I told her I might need a minute, and I called her as soon as I was done, and she flipped off. We got into a big argument over the phone, text wise, and she didn't let me see my daughter.
So what was the need a minute situation?
I needed to stop at the hospital. My significant other is currently, she's 7.5 months right now. And there was a situation where she felt like she should go to the hospital because she's going to be a first-time mom. And as a responsible father, I wanted to make sure that I took her to go take care of this thing. And I texted Cassandra and told her, hey, this is what I got going on. And we can get into it if you want, but long story short, she didn't let me see my daughter when I went down there.
Well, if you're not available to see your daughter because you're at, I'm sorry, Mr. Ingersoll, but if you're not available to see your daughter because you're at the hospital, how is she going to let you see your daughter?
I was available.
How's that?
I had a pit stop to make. Well, so I called at 7 o'clock in the morning. 3 hours goes by, and I try to call again. I get no answer. I get a text. I say, hey, I might need a minute. I had to make a pit stop. Her reasoning wasn't even my pit stop. It was like, either way, I mean, I guess you could let her explain it.
Yeah,
if you
can I
really
talk?
I'll give you a chance in a minute, Ms. Ingersoll. Just be patient. I'm talking to Mr.
Okay, thank
Ingersoll.
you. Yes, sir, thank you.
Please continue, Mr. Ingersoll.
So, Your Honor, I drove down to Tennessee. I called super early in the morning. She said, I'll call you when we're ready. I had something come up. I said, hey, I might need a minute. When I was done with that, I said, hey, I tried to call. I stopped by the house. I texted, and she wanted to argue instead of letting me see my daughter. And then she let me see my daughter the next day.
When were you done with your pit stop at the hospital?
Maybe an hour and a half later.
What time of day?
Noon. Before noon.
Well, I wasn't there, so I can't tell you what day and time it was. You have to tell me.
It was noon, Your Honor.
All right. So you were available from noon forward. What contacts or attempts to contact did you have with Ms. Ingersoll to try to meet with your child?
I tried to call. I knew she was at work, but she had no problem communicating text-wise back with me. I made multiple attempts. I begged her. I pleaded with her. Like I'm any more attempts would have been pathetic. Like I think I tried hard enough. Like, and the problem is she doesn't have control of my life, and she's doing everything she can to control every situation because that's the only control she has left.
All right. Mr. Ingersoll, I'm more interested in times and dates and facts as opposed to opinions about the other party. So if you could help me out.
We had an agreement that I was going to come down on the 30th and the 31st of March. She knew I was coming on the 30th. I called at 7 o'clock in the morning. I tried to call her back. She said they still weren't ready. And I said, hey, I might need a minute. And when I was ready at noon, she dodged me. They went to the park and went out for ice cream or lunch or whatever else it was. But they did that to purposely dodge me, knowing that I was down there because she was mad about it.
Again, Mr. Ingersoll, I don't need you to tell me what you think she was doing. I just need to tell me when you missed and what happened from your side, what you saw and what you heard. So is there anything else that you want to add?
Yes, that I went down to Tennessee and I didn't get to see my daughter on the 30th like we had agreed.
Yeah, I got that.
Okay, that's it.
Thank you. Ms. Ingersoll, your side of the story, please.
Okay, so my whole issue is that when we first went through this whole agreement, when we were in court with you a couple months ago, it was agreed upon that his significant other was not to be around the situation until June, when I took my daughter up there to meet her after all of this had gone down. She was not supposed to be down here. She wasn't supposed to be involved in anything. And he did call me at 7 o'clock in the morning. I answered. I said, give us a little bit to get ready. I got my daughter up, ready to go, all of the whole thing. And then I said, all right, we're ready. And he said, okay, I got to go to the hospital. I said, oh, are you okay? And he said, yeah, she's worried about something. So it's real convenient that 10 minutes before he's supposed to come meet up with us, his significant other, who is not supposed to be involved in the situation at all, needs to go to the hospital.
Ms. Ingersoll, hang on, slow down. I said the same thing to Mr. Ingersoll. I don't need the comments about what the other side is or shouldn't be or might be doing. I just need you to tell me times and dates and places. Who did what? I don't need the comments about he's bad or he's this or he's that or his significant other is this or that. So
I'm not trying to say that. I'm trying. Okay, but I'm telling you, sir, that it was agreed upon that his significant other was not to be involved in any of this situation until June. He chose to bring his significant other.
Slow down. Hang on just a second.
I did. Okay, I did.
Just, you've told me twice now that it was agreed upon that his significant other would not be there. I'm reviewing Hank. I'm looking at the order and I don't see anything in the order that says that. Can you point me to something that says that?
It was said on record. It was said on record by you that his significant other was not to be involved. It says in the record, details stated on record.
I don't
His
care if it
significant
says it
other
in
was
order
not
or
to be down
not.
here and not to be involved in
It
any of
makes
this
sense.
process until June. He was supposed to come down here by himself 4 times over the next 4 months to spend time with his daughter, not be worried about his significant other.
All right.
As usual,
So
I'm
he
simping.
brought her down here. It caused a problem. He had to remove himself from coming to see his daughter 10 minutes before he was supposed to be here so that he could take his significant other to the hospital for 2 hours. And by the time that 2 hours had passed, yes, me and my daughter had already gone about our day, and I had to be to work in a couple of hours. I didn't know whether or not he was going to show up with his significant other. I didn't, I knew what the agreement was when we agreed upon it, and I didn't want to be involved in that situation. So I gave that day a rest. I said, I can't deal with this today. It's too much for me. I emotionally, mentally, physically, I can't. Like, he has caused me severe PTSD, and he has put me in situations before that I couldn't get out of. And
All right.
it
Ms.
makes me really
Ingersoll,
uncomfortable.
Ms. Ingersoll, again, I don't need the details of
Well,
why
okay, I
necessarily.
understand.
I
I'm
just want
just
to
trying
know
to explain
when.
why. Okay, I'm
All
just
right.
trying to explain why it made me uncomfortable that his significant other was down here. That's all I'm saying.
I
It
appreciate.
all intertwined. That's the reason why I didn't meet up with him, because I was worried that she was with him, and it was
All right.
agreed upon that she wasn't to be down here.
What happened the second day that you agreed to allow your daughter to have contact with him?
Nothing. I went and picked him up from the hotel room. We went and did the concert as we were supposed to. Everything went fine that day up until I went to drop him off, and he wanted to bring up what happened the day prior and how I don't have control over his life, blah, blah, blah. I understand that. I don't want control over your life, but you agreed to not have her around until June. So there's no reason for her to be around until then.
So what you're telling me is the second day she was not there.
Correct. Well, she was at the hotel room. He left her at the hotel room.
All right. What prevented you from doing that the first day?
That part though.
Mr. Ingersoll, I don't need your comments.
Yes, sir.
Ms. Ingersoll, what prevented you on the first day from, once he told you that he was available afternoon, from
because I
picking him
didn't
up?
trust him to not show up with her. I don't trust him. I was having anxiety, like I was having a severe panic attack
But you were able
about
to do
him
it on the
showing up
second
with
day.
her.
All right,
What?
but you were able to do it the second day, right?
Because I took a breath, yes, because I let myself relax and I took a breath, and I wasn't going to meet up with him the second day, but I made an agreement in order to prove that he wasn't just going to show up somewhere with her. I said, I will come to the hotel room. You come outside by yourself. I will pick you up. We will drive the hour and a half it takes to get to the concert with our daughter together. And then when the concert's over, I will drive you back to the hotel room. That way I knew he wasn't just going to show up with her. I made a separate agreement outside of the first day's agreement, and we didn't have an agreed upon time the first day. He just called me at 7 o'clock in the morning and was like, all right, you ready to go, bitch? Like,
Don't need the language.
Okay. Not even what I said.
Mr. Ingersoll? Mr.
I said,
Ingersoll.
who's ready? Yes, Your Honor.
Mr.
I did
Ingersoll,
not use that language.
I don't need your comments either. So both of you just need to take a breath and slow down. So here's what we're going to do. The court ordered 2 days in a row, weekend daytime visits. Through his own reasoning, he missed the morning of the first day. That's on him. Unfortunately for you, Ms. Ingersoll, it was on you that he missed the afternoon of the first day. So he's entitled to a makeup. You're supposed to have time in June here in Michigan. That there will be 5 consecutive day visits, no overnights, supervised by you or a designee. I'm going to add a half a day, 4 hours to that. So he gets 5.5 now when you're here, when he's here, excuse me, when you're here in June for him to have his parenting time. You can either do that or you can give him some additional time on one of the other weekend visits that he's going to have in the state of Tennessee. Which would you rather have, Ms. Ingersoll?
I don't mind giving him extra time on a day.
Oh my God. Well done, Judge Helsenak. He listened to these goofs and then actually did something semi-reasonable under the circumstances.
He's down here. We've gone to the zoo since then. We've already had 2 other visits since this whole thing went down, and everything has been fine. And he's hugging me and telling me he misses me
Ms.
and all this
Ingersoll,
other stuff.
Ms. Ingersoll, slow down. I don't need all of the additional information. The question was, do you want to do it in Tennessee or do you want to do it in Michigan? So I assume that you want to do it in Tennessee.
Yes, that would be fine.
Mr. Ingersoll, when would you like to do the additional 4 hours in the state of Tennessee?
I was wondering if we could do it in Michigan. I mean, considering she's the one that violated the day, like, can I ask respectfully why we're giving her the, like, don't you think we should be asking me? I mean,
oh my God.
And can I get a new mediator? Is there any chance that we could get another mediator? Like, you know, every time I've gone down there, it's a problem.
God.
Like, I kind of feel like unintentionally, you and the courts kind of set me up to hang out with my ex-wife, and it's ended in
Whoever is talking is losing.
disaster, in arguments, and I think it's slightly inappropriate, some of the things that she brings up and says in front of the children, and I would strongly urge this court to give me an option to have an additional mediator besides just her. Like, it seems like it's pretty closed off, and you know, I just got back from Tennessee, and this situation, you know, and,
Right.
and by the way, the 5 days in June, that's unsupervised, right?
He goes full Karen and then asks for the manager. You've got to be kidding me. You had a point. She is controlling. She has a point. Your new significant other should not be near that child. But you could have worked that out. He saw that your way, and then you're going to go full Karen on him. Oh my God.
Because that's what it said last time. It's supposed to be. Earlier in your motion, you just said supervised by her, and that's not true. Okay, I'm done.
The court order says in a 5 consecutive day visit, no overnights in Michigan, supervised by defendant mother or her designee in June. So that's what we're going to do. The question is, when do we do this makeup 4 hours? Mr. Ingersoll is asking. Hang on, I'm not done. I'm not done. Mr. Ingersoll is asking for that to be done in Michigan. Ms. Ingersoll is asking for it to be done in Tennessee. I agree with Mr. Ingersoll because it was Ms. Ingersoll's actions that prevented him from doing it. We'll do it in Michigan. It will be added 4 extra hours to the time that he's here in, she is here in Michigan. Your request, Mr. Ingersoll, for someone other than me or some other mediator is denied. I am
No. I don't.
Your
Honor, I don't mean you. I mean somebody to supervise the visits with my daughter.
No, you are the dad. She is the mom. You have
and
to
the
get
mom is
along.
doing a bad job of momming, sir.
Mr. Ingersoll, I don't need your extra comments. You're the dad. She's the mom. The two of you got to grow up and learn how to be adults over your daughter.
Mom
The two of you, if you can't, it's very obvious to me that the two of you can't talk to each other. That has to change. The only
We do,
only
sir.
way.
Okay, hang on. I have something to say. Can I say something, sir?
No.
Oh.
I'll get it now. Sorry, it took 3 of you.
This is the problem. The two of you can't talk to anybody. Period. No, I'm not listening to either of you anymore. That's why I muted you. Grow up, act like adults, become adults for your child. If you don't, you're going to screw her up. We're done today. He's getting 4 hours in Michigan. I'll add it to the court order. Case closed.
Your Honor, I do want to bring to the court's attention, there is an additional parenting time violation that's in the process as well with friend of the court.
I'll hear it when it gets here.
Thank you.
Matter of Hope Bedford versus Heather Bender, file number 268176 PH. This is the respondent, Ms. Bender's motion to rescind or terminate a personal protection order. She's in the courtroom in pro se. The petitioner, Ms. Bedford, is also in the courtroom in pro se. Would you both please raise your right hands?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
All right. The burden of going forward and the burden in proceeding and maintaining a PPO rests with the petitioner. That is the burden of persuasion in the hearing on a motion to terminate or modify an ex parte PPO. That's cited in the Pickering case. As a result of that, Ms. Bedford, you will go first and explain to the court why you feel the motion should be denied and why the personal protection order is continue to be proper. Go ahead, please.
Good morning. I am Hope Bedford. I am asking for the current PPO that I have against Heather Bender to remain in place. I was never told that I was barred nor could not come back to the establishment under any circumstances. I am not trying to get away with anything or use any of my personal relationships as leverage for personal gain. I also do not work for Huron County. All I'm trying to do is protect myself. On February 13th, I had my first encounter with Heather Bender. She made the threatening comment, "I hope to see you around again." I had no further contact with Heather until March 14th. On the night of March 14th, I did not bring an entourage of people to be present or to stir up trouble. I was simply out to celebrate a friend's birthday. I did not go into the wash on March 14th in anticipation of conflict or assault. If that were the case, I wouldn't have gone at all. When my boyfriend and I arrived at the wash, Heather was screaming our names. I decided to just ignore her and go over to my friends. Neither of us were approached and told to leave the establishment. I was approached by Heather. I told her to get away from me, and this is when Heather assaulted me. After the fight got broken up, I was outside on the phone with 911 in the truck. Heather proceeded to approach our vehicle and started to bang on the window and was cursing. I had rolled down the window to tell her to back away from the vehicle and that I was on the phone with 911. She decided to try to reach into the vehicle and assault me further. Heather had left the side of the vehicle to later return and continue the same behavior. I do want to note that I was not intoxicated due to the fact that I had stopped drinking back in early February.
Okay, before the alleged incident on March 14th, you said you had not been drinking since February?
Yes,
Okay, so,
beginning of February.
okay, but bottom line, you're testifying that you didn't consume any alcohol that evening.
Yes, Your Honor.
Okay, I mean, and it may be presumptuous, but when I heard you say, when you were referring to the March 14 incident and then saying you hadn't had alcohol since the 13th, I was kind of questioning how that applied, but now I understand. Anything else?
No, Your Honor.
Okay. Ms. Bender, your response, please.
I want to start by saying that the mental and emotional toll that this has taken on me has been significant. At the time I started working, I will not be referring, I will be referring to my place of former employment as the restaurant because I don't want this to affect the business.
And the court had a previous hearing regarding that as well, and the court never mentioned it either.
Okay.
I agree. I think that's great.
At the time I started working at the restaurant, I was already managing severe anxiety, including social anxiety. I pursued this position with the intention of confronting those challenges in a constructive and positive way, being forced to interact with people. All I have learned is that through this experience, I came to understand that a bar environment and all the negative social dynamics that come along with it are not suited for me. Since this has happened, I do not want to leave my home. I only want to go to work and necessary appointments. Starting from 10:56 on the night of March 14th, I received an offensive Facebook message from Hope's mother, which I ignored. However, what I could not ignore was the additional Facebook post that she made expressing that she was a dangerous person, a fucking psycho, that I poked the bear, that I was about to meet Natalie Bedford in all capital letters, with comments asking from people who commented on the post if they needed to come up here and take care of business, and that I was about that I had fucked around, and it was fuck around and find out season, and I was about to find out is what Natalie Bedford had said, and that they all needed to stay tuned. I feared for my safety. I don't know these people. She didn't state my name in these posts, but given the dates and times that these were posted, it's pretty obvious, especially since they disappeared after the paperwork was served to Hope. The amount of increased anxiety that this whole situation has caused me is something I cannot even describe. I used to enjoy going on long walks alone, but now I'm too scared to go. I would not be sitting here today if Hope had just listened. When told not to return to the bar when I was there, this isn't a situation where you can call your coworkers or have your coworkers make a phone call to a friend. There are rules in place in which I outlined in my statement as section MCL, section 750.522. If a bartender tells a patron not to return, they are acting in the scope of their employment, and that order is legally binding. If a patron returns, they can be charged with criminal trespass. In Emily Beaver's statement, which Hope presented in her statement, it says that she contacted the owner. However, you will clearly see in a signed statement from the owner and manager that there was no contact made. The words barred or banned were never used. She was simply told, do not come back if I am there. Hope is the one who made the decision to come that night. Emily had been there long before Hope and knew that myself and Maddie were there that night. I have tried to get a copy of those statements through the apparent police report that there is from Huron County officers, but I was told that I am unable to since there is an ongoing investigation. So knowing that we were there, she chose to come. She chose to ignore me when she and Tyler Hansen walked in the door, and I immediately asked her to leave. They just continued to walk over to her coworkers, and instead of leaving when approached, she decided to just say, "You're a fucking bitch." Did I have too much to drink that night? I sure did. I could file charges against Hope for criminal trespassing. I could file charges against her mother for everything she posted on Facebook and the fear and anxiety that it has caused me, but I'm not going to. I don't need a PPO to stay away from Hope. Prior to this first incident, she was asked to leave my place of employment. I had no idea who she was or where she worked. Other than eating at her place of employment, there are no situations in which I would see her from today forward. I am not a bar person. She frequents bars. We certainly don't hang out in the same social circles. And furthermore, I don't need a piece of paper to tell me to stay away from her. Because unlike Hope, if someone tells me not to do something, I'm not going to do it. Unfortunately, I cannot tell you every detail of the scuffle that occurred that night, but it's pretty clear given the bruises and the sore nose that Hope was not the innocent victim. Hope is making me out to be a violent person who she needs a PPO protection from. I am far from that. I am a mother, I am a caregiver, I am soon to be grandmother who has never had so much as a traffic violation. I've said it once, I'll say it again. None of us would be here today if Hope had not made the choice to come to that location, knowing that she was not supposed to be there.
I may have a couple questions. First question is on March 14, were you on that night working?
No.
Okay, you were just merely
I was there.
A
yes.
customer, like anyone else?
Mhm.
Okay. Do you have any comment regarding the allegations of activity outside the bar afterward?
No, and I told this to the state police who are doing an investigation, that
Okay.
I have no recollection. As I said, and will fully admit, I had far too much to drink.
Understand? Understand. Okay. Any other proofs?
I do have like a victim statement.
Ma'am, are you a whore?
What do you mean a victim statement?
Just kind of explaining like things that I've experienced since this incident on March 14th.
All I'm looking for is what happened on the night in question. That's all I'm looking for.
Okay, so on that night, me and my boyfriend had went up there to celebrate a friend's birthday. And so we entered the establishment and almost immediately our names were getting yelled out by Heather. I had just decided to just ignore her. You know, I wasn't there to cause any trouble or to engage in any sort of bad behavior. I was only there to celebrate a friend's birthday, so I just decided to ignore her. I went and was talking to one of my coworkers, and before I knew it, Heather had approached me, and I can't quite remember what she had said, but it wasn't along the lines of "you cannot be here." I told her to please get away from me, and that's when she proceeded to put her hands on me. After that fight got broken up inside, I had went outside and called 911 to report what was going on, and Heather came out to the vehicle twice when I was on the phone with the police. And was banging on the window, cursing at me, cursing at my boyfriend.
Okay, I do recall all that. Is there anything different or anything additional other than what you've already mentioned?
No, Your Honor.
Okay. Well, by way of history in this matter, a personal protection order had been requested by the petitioner, and that was brought to the court on, I think it was March 16th. March 16th. And the court has 24 hours to address an ex parte personal protection order. Ex parte personal protection order means it's one-sided. It's made without the other party having a chance to respond. After the court read the information within the petition, as well as any reports, the court issued the personal protection order. The personal protection order was then served upon the respondent, in this case, Ms. Bender. And after that, Ms. Bender properly filed a motion to terminate within 14 days of service. There's no question about that. She complied with the statute in court rule. Now, the burden of proof has stated the burden of persuasion in a hearing held on a motion to terminate or modify an ex parte personal protection order is upon the petitioner, in this case, Ms. Bedford. And the court has heard the testimony, has heard or has read the petition again, as well as the attachments to it. And frankly speaking, this started out on a bad foot on February 13th. On February 13, 2026, according to the review of the petition, the petitioner went into this particular establishment, and as a result of that, there was a conversation with the petitioner and someone else or some other folks, which was overheard by the respondent. I believe petitioner had no idea that some of the topic of conversation was the respondent's daughter, which clearly would have set any parent. And there was some discussion from the respondent to the petitioner about don't be talking like that, words to that effect. I mean, I'm paraphrasing here. And that started the ball rolling. There was a comment also made by the respondent along the lines of, you're not to come back into the establishment. Well, there's contradictory evidence on the record. in this proceeding because relative to this banning, because according to the petitioner, she was not barred from the establishment. Respondent says not only was she barred, but petitioner's comment about someone else reaching out to the owner of the establishment saying whether she or asking whether she be barred or not was never had. That's a respondent's position. That's not sworn testimony, but it's at least contained within the record. I have sworn testimony from the petitioner that a phone call was made and apparently the petitioner was not barred. But regardless, this all started February 13th. Fast forward to March 14th, petitioner enters the establishment. Respondent noticed, according to the facts contained within the petition and hearing the statements of the parties. Respondent noticed that the petitioner entered the establishment. Words are already started, and responded, I give her credit under oath saying, hey, look, I did have too much to drink. She can't recall specifics regarding this. She can recall certain things, but not everything, which is understandable. But I give her credit for at least being honest and not coming into the court saying, well, I knew this and I knew that. She did her best. There was a confrontation. It appears the confrontation was the respondent coming toward the petitioner. Who pushed who, I don't know, but respondent approached petitioner. Petitioner appeared to be in a situation of being threatened. And then, for all lack of a better phrase, all hell broke loose. What happened? There's pushing. There was a punch thrown at another individual who's expecting, and according to what I read in considering the prior petition or another petition in this matter, it wasn't either party involved with that. It was some other individual inside the establishment. Regardless, petitioner has the wherewithal to say, look, let's just get out of here. So petitioner leaves the establishment. And clearly there's one unwarranted contact between the individuals inside the establishment. You need two. Then petitioner is outside in a vehicle calling 911. At that time, and it's uncontroverted because the respondent doesn't recall this, and it's understandable. Respondent comes out of the establishment, approaches the vehicle, that's time 2, and yelling, wanting to confront the petitioner. Windows rolled down. Get away from my vehicle, says petitioner. Respondent, apparently, according to the testimony, throws a punch or some sort of an assaultive behavior upon the petitioner. That's the second incident. Based upon all of that, the court finds, under the circumstances, that the petitioner has met her burden of proof relative to the personal protection order. I will note, though, that when it comes to the petitioner's mother, that's a whole separate issue. And if that's true, clearly, Ms. Bender has the opportunity to address that if she wishes to, but I can't render legal advice. But what may have allegedly occurred between the respondent and the petitioner's mother is of no relevance to this court, because we have to look at the activity that occurred both inside the establishment and right outside the establishment. Personal protection order continues. That is.
Oh man, I give both of these judges credit for listening to these morons, but still doing something reasonable. Holy Toledo. This is out of control. Where are we at here?
Can I say the words that she said, or?
Sure. I need for you to tell me what went on.
I'm not on that whole shit. I'm not with that whole shit.
Coochie. Gotcha.
All right, that's fun stuff. That was all Alyssa's fault so far. Let me see if I can find some of the stuff that Zach sent me. It looks very promising.
Morning. Mr. Albatron, you're muted and can you hear me?
Good morning, Your Honor. Yes, sir, Your Honor.
Okay. All right, we'll go on the record. This is in the District Court of Greenwood County, Kansas. Case is entitled Richard Joseph Attenburton Petitioner versus Christy Marie Albritton Respondent. Case number 25 DM 57. Petitioner Richard Albritton. Is that how you pronounce it? Albritton?
Albritton. Close enough, Your Honor.
Yeah, sorry. And that last one, I was streaming off the live. Apparently, I think that just happened. I was streaming off a live stream, so I couldn't fix the volume.
All right, appears in person pro se. There are no other appearances. We appeared on this case back in January, on January the 5th. At that time, there was a request made for service by publication. The court took testimony and found that Mr. Albritton had made due diligence in attempting to locate her. The court did grant the motion to allow publication notice. That's now been accomplished. That was done in Mississippi. I do have an affidavit, proof of publication indicating that publication notice was done 3 consecutive weeks as required by statute. The last one being January 28th of 2026. There has been no answer filed by the respondent, Christy Albritton. Mr. Albritton, are you ready to proceed to final hearing at this time?
Yes, Your Honor.
All right, I'm going to have you raise your right hand. I'm going to administer an oath. You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, and you are Richard Joseph Albritton, is that correct?
Yes, Your Honor.
Go get it, brother. Get out. Get out.
And you are seeking a petition for divorce from Christy Albritton, is that correct?
Yes, Your Honor.
Were you a resident of the state of Kansas for the 60 days prior to the filing of this petition for divorce?
Yes, Your Honor.
Do you remain a resident of the state of Kansas?
Yes, Your Honor.
When were the two of you married?
March 1st, 2003, Your Honor.
And when were you separated?
February 3rd, 2014.
All right, so you've lived apart from her since 2014. At the time that you
For me, it happened in Louisiana. It didn't work out any better.
separated, did you all divide up your assets and debts?
Yes, Your Honor. Actually, I was gone in military service. I was on the other side of the country when she informed me she wanted a divorce. When I graduated intelligence school and went home, she had removed the majority of the things she wanted from the household and then moved on. Afterwards, I left everything that she wanted in a storage I paid for a month. And then I moved back to California approximately 7 to 8 months later. We did both go bankrupt. And then had a form stating that neither one of us would be responsible for the other's bills if anything from that point on was incurred.
Oh, dude, you got so lucky.
Right. Do the two of you, did you ever own any real estate together?
We had a house together back then. And when I did return home, I found it had gone to foreclosure because she was not paying the money that I was putting into the account to pay the house. She was keeping it to move out, to move in with somebody else.
Right.
Meanwhile, this guy was still too nice about it, but I love the way he handled it. She's like, "Oh, I'm a hoe," and he's like, "Okay, I'll just carry on with my life." That's the way you do it.
When did you last have contact with her?
Last I had contact with her was at a police station for an exchange of children that were minor at the time, 2014 or 2015. That has been over a decade.
All right. Do you currently own any real estate?
No, Your Honor.
Do you know if she does?
I have no idea, Your Honor.
I highly doubt it. Her only method at obtaining real estate is to take it from some guy, and since she's currently married, she can't legally pull that off at the moment.
Did the two of you own any? Do you currently have any joint assets or debts with her?
No, sir.
Right. Are you seeking any property she may have in her possession?
No, Your Honor.
All right. And you're not asking for spousal maintenance?
No, sir.
So basically the asset division of assets and debts was completed.
So far, this guy's handling this like a man. He screwed up, but then you part ways. You're nice to the extent you can be in parting ways, and then you just move on with your life, and you're happy as hell that you dodged the bullet of spending more time with this woman. You're just full of gratitude, frankly. The only question is, did you learn your lesson? Don't do it again. Do not do it again.
Long ago, do you feel that division of assets and debts was fair, just, and equitable to both of you?
I am fully content with the outcome. It is fine.
Yes.
It's been so long.
Yes, I'm happy with the distribution of zero assets as we both filed for bankruptcy. Just say yes, sir. But he's doing great.
Your Honor, I'm just looking to move past it.
Understood. All right. Are you active duty military currently?
No, sir. I've been out since December of 2014.
Okay. And there are no minor children of the marriage currently. Is that correct?
That is correct, Your Honor.
All right. Is there anything else you feel needs to be placed on the record by way of testimony this morning?
No, Your Honor.
All right. I do find that 60 days have passed since the filing of the petition for divorce. The court finds that there has been proper notice, that there has been no answer filed by the respondent, and she does not appear in person. I will grant divorce by default on the grounds of incompatibility. The parties have been long separated. The division of assets and debts is fair, just, and equitable to both of them. The court is not awarding either party spousal maintenance. There is no real estate to designate. All right, the divorce will become final, Mr. Albritton, once I've signed this decree of divorce that you've already signed, and then that will get filed with the clerk in Greenwood County. And then once it's filed with the clerk in Greenwood County, then you will be officially divorced. You're not to contract for marriage for a period of 30 days following the filing of the divorce. Do you have any questions?
Yes, Your Honor. No, Your Honor.
All right. Well, good luck to you, Mr. Albritton. I know this has been kind of a long process, but I'm sure some relief to getting it completed. So
My girlfriend will be ecstatic. I've been with her for many years now, and she did not enjoy me having a wife. So
Oh no, he hasn't learned a damn thing. And he seems like a nice guy too. I wish you well, Richard. I do.
I do appreciate everything, and I appreciate your time, Your Honor. Thank you very much.
all right. Good luck to you, Mr. Albritton. We'll be in recess. Have a good day.
You have a great day, Your Honor.
Damn, you may kiss your bride.
Okay. So we were just gonna do a payment plan. I didn't know if we needed to talk to somebody for that or.
Okay, and does he live with you, ma'am?
Yes.
Okay, where's his dad?
His dad's here too, but he's outside.
Okay, he needs to come in because this is his son. So can you get his dad to come in, please? Thank you. And I don't have orders, Maria.
They want you on the chat because I'm stepmom now, so they want you. Next stage. Yeah.
Good Lord. Shout out to Zach. There's some serious editing going on here. He's keeping the minor out of it, which is good. Thank you.
Hi, sir. What's your name?
My name is Alberto Hernandez.
Okay, thanks. Same name as your son?
Yes.
Okay, thank you. It's not that we didn't want the stepmom, but since you're his legal parent, since you're his parent, we need you to be here. So,
Okay.
Mr. Alberto,
Plus, we don't want the stepmom.
is he junior? Is he junior?
Yes.
Okay, so Alberto Jr. has from June 23rd of 2025 running a red light and no driver's license. From November 18th of 2023, a speeding 45 and a 30 and no driver's license. From July 1st of 2024, a no seatbelt and no driver's license. From April 30th of 2025, he has a no driver's license, no insurance, failure to signal distance before turn. From March 11th of 2026, a no driver's license and no insurance. And from September 2nd of 2025, a no driver's license, no insurance, failure to signal distance before.
Yeah, he's a horrible driver. Might be the fact that he doesn't have a license and never had driver's ed. That might play into it.
Turn. And August 18th of 2025, a speeding in a school zone and no driver's license. Can you tell me, Mr. Hernandez, why is this child driving?
Well, he was getting to work, back and forth to not to work, school.
But he doesn't have a driver's license. He just is going to turn 16 in a few days. So
Yes.
Some of these tickets are from 2023. Why is it okay that he's driving?
Oh my God. What was he,
How did
12
he get
when
to
he
school
started?
before he was 13 years old?
I was taking him and stuff.
Why can you not take him until he has a driver's?
I was taking him and stuff. Oh, shit.
License, Mr. Hernandez?
I ended up getting a job, and that kind of was getting into with the deal with getting him to school and stuff.
Okay, and why then why did you not apply for a hardship license?
I just didn't.
You know.
I didn't know about that.
How many has he been in accidents?
No.
He's just not a good driver.
Yeah, basically.
Okay, so do you have your driver?
He's like Toonses, the driving cat. You can't blame the kid. Nobody ever taught him. They just threw him the keys and said, "Get to school." Oh my God. This is only funny because nobody's gotten hurt.
Driver's license, Mr. Hernandez?
No, I don't.
Okay, does his stepmom have her driver's license?
Yes.
Yes.
Okay, so here's the situation. She had indicated before you came on, I guess you as a family had discussed this and just wanted to set up a payment plan. Do you have any clue what the fines and court costs are on these cases?
No.
He has, without me even adjusting this, because I truly think that these fines should be higher. Without me even adjusting it, it's $3,500. Can he not ride a bike to school or get a ride with a friend?
He's gonna have to.
Well, I mean, it's $3,500, and not only that, but if he enters into a payment plan, a juvenile criminal record is different than, or a record with my court is different from a driving record. I can't tell you what DPS does to his driving record, even though he's a juvenile. They may say, it may be forever before he gets a driver's license. I don't know what DPS does. So I'm happy to enter into a juvenile payment plan or to a payment plan, but I need to know kind of what your family's intent is on getting these paid and what you're going to do to stop him from driving. He needs to not be driving until he has a license, period.
Yes.
So
I don't know how this works, but it seems to me that there should be some sort of negligent entrustment theory and dad should be paying this fine, not the kid. That's, whatever. I'm sure we could get Regier to look through the code and figure it out. Oh, we're in Texas. Somebody down there. You get, but this is insane.
what are y'all going to do?
Well, for one thing, he's not going to be able to drive anymore.
Well, Alberto Jr., when was the last time you drove? Today?
Since my last ticket.
That was just like 3 weeks ago, 4 weeks ago. So how'd you get back and forth to school since then?
My sister has been taking me.
She older?
Yes, ma'am.
She have a driver's license?
Yeah, she's getting.
Judge immediately asked the question that we all had. We all had as soon as he said it. My sister's taking me. What is she, 9?
Anyone.
How old is your sister?
She's 19, almost 20.
Is she driving this? Which car is she driving?
A white Dodge Charger.
Yeah, a Challenger?
No, Charger.
A Charger. Okay. Whose car is the Challenger?
Mine.
It's my stepmom's.
Okay. Whose car is the 2008 Cadillac CTS?
A white Dodge sounds like a cop car. Is that like an old cop car that they bought? That's what it sounds like to me.
It's also my stepmom's.
Okay. So, what do you want to, how old are, what grade are you in? What grade are you in?
I'm a sophomore, ma'am.
Okay. What are you thinking at this point you want to do when you get out of high school?
I want to end up being a mechanic.
Like an auto mechanic?
Yes, ma'am.
Okay. So guess what auto mechanics have to do? Guess what they do? Not only do they work on the car, but we see auto mechanics in here all the time. They test drive vehicles, right?
Yes, ma'am.
So if you want to be an auto mechanic, you need to have a valid Texas driver's license because you want to be able to test drive those vehicles out on the road. We see people in here all the time who are mechanics because they go out and they test drive their client's vehicle that doesn't have good registration or whatever. But Mr. Alberto Jr., you are going to set yourself up to make it very difficult to get a driver's license because 1, 2, 3, 4, 5 of these citations are moving violations, number 1. Number 2, 1, 2, 3. 3 of these are no insurance citations. They all create big barriers for you. So because you are a juvenile, I will tell you one more thing.
On the upside, you'll be the most experienced driver in driver's ed by a wide margin.
And this is something that, Dad, you're going to need to really think about. When you turn 18, because you're a juvenile, you will have the right to file what's called a motion or a petition for expunction, where you can come in and try to get your records kind of wiped out. You are going to be the person who needs this. I tell juveniles all the time about this, and then I go, but it's never going to apply to you because you got this one ticket. But you are the person who needs to be following up on this when you're 18 or 19 years old and going,
Yes.
what can I do to get this cleaned up? Because if you get it cleaned up, not only do we have to wipe it out of our records, it's like erasing it. We have to send it, if you ask for it, to DPS, and they have to wipe it out. but you have to do it the right way.
Yes,
So-
ma'am.
and I can't do it for you. That's something you and your family have to take care of. But boy, you need to stop driving until you get your driver's license.
Yes, ma'am.
So I'll let you set up a payment plan on all these. But you better not get another ticket. You better not be driving.
Yes, ma'am.
There's no excuse. And Mr. Hernandez, I respect the fact that you're working and it's a hardship for you. But you're so close to this child being graduated from high school. Let's just get him. Let's focus on doing what we can so that you can eventually get your driver's license. Okay?
Yes, ma'am.
Okay, so on any of these, do you think, well, I really wasn't guilty and I really think I should have a trial? Or you're like, no, that was really guilty. Okay. Okay. So you're going to remember when you're 18 or 19 years old to come back here and file to try to get these cases wiped off your record?
Yes, ma'am.
Okay. So are you entering pleas of guilty or no contest to each one of these citations?
I'm gonna do no contest.
Okay. I'm going to find you guilty on each one of these. I could tell you every single fine and fee, but it adds up. I think the actual total is $3,500. It might be even, $3,500 even. Now, you have two choices, and that's the conversation you can have with your dad, and I know your stepmom's right there too. Because you're...
Oh my God, they should have gotten an attorney. An attorney said, oh, they know they screwed up, blah, 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 and they would have gotten a few of these things pitched in exchange for pleas on the others. And he would just have less convictions to deal with.
Juvenile, you can pay $35 biweekly. That'll take you forever. Or you can do community service. But again, community service is going to cause you a transportation issue.
Yeah.
If you do community service, it's 187 hours of community service. It's a lot of hours. So what are y'all thinking you might want to do?
I'm thinking I'm gonna do the payment plans.
The 35?
Bi-weekly.
Yeah, I can do 35, but I can set it higher. 35. He's not going to get 35 done in,
So could we do like 50?
Yes.
bi-week?
Yes.
Okay. And if once he gets a job, we can raise it, right? If he gets a job.
You can raise it or you can leave it like that, and he just pays in
Judge, if he starts selling drugs at school, he can knock this out in a couple of weeks.
more so that he gets ahead. So if you do 50 biweekly, he's only going to get $1,300 paid the first year. So I'll do the 50 biweekly, but Alberto Jr., if you get a job, you better be paying in. And I want you to be, now because you're a juvenile, these payments have to come in person. I can't let you make payments online.
Okay.
I need you, Alberto Jr., to be making sure those payments are made. So no, I don't mean any disrespect to dad or stepmom, but if you send that payment up with somebody, you make sure that you get that receipt back and you start a file of your receipts. Okay. We give a receipt for every cash payment. If you send it with your sister or with a friend, you say, I need the receipt. Okay.
Yes, ma'am.
Because guess whose responsibility is when you turn 17 to make sure these are taken care of?
Mine.
100%. So the other problem and I'm sorry, I know I'm lecturing you, but you kind of deserve it. Okay. So the other problem is when you turn 17 on April 13th, 2027, instead of going out and celebrating, you have to come see me on that day. Because then I have to switch this to an adult payment plan. Okay.
Yes, ma'am.
So if you don't come see me, I send you a notice going, hey, you didn't come see me. And then if you ignore that notice, like you ignored all these tickets, you and your family did, then I'm going to issue warrants for your arrest. And please don't think that we don't issue warrants for arrest for 17-year-olds. Please don't think that I don't get to talk to 17-year-olds in jail all the time who ignored their tickets. You can no longer handle this the way you've been handling it. I have rarely seen a juvenile with this situation. It's an utter disregard for the law. And I can't really lay all the blame on you, even though I'm sure nobody forced you to drive a vehicle. Okay?
Yes, ma'am.
You needed to go, I need to find a ride to school. I cannot drive this car, because now you've created a huge hole for yourself that you have to get out of. Okay?
Yes, ma'am.
You saw all these other people here today. You realized that all these other people don't get however many, this 15 cases or however many this is. People get 1 ticket or they get 2 tickets. They don't get 15 tickets. Don't be that way. Okay?
Yes, ma'am.
Don't limit your ability to have a great future.
Yes, ma'am.
Okay, Mr. Hernandez, is there anything else that I haven't lectured him on or you on that I need to say?
No, ma'am.
Okay, we're gonna send you a payment plan. It's going to tell you it's gonna be $50 bi-weekly. And I'm gonna start that. Which day of the week is better for you, Mr. Hernandez, for him to come up and make in-person payments?
Fridays.
Okay, so
Fridays.
can I start that tomorrow or do I need to start that next Friday?
Next Friday, please.
Okay, I'm gonna start it next Friday. Do not miss payments, Alberto Jr., okay?
Yes, ma'am.
It's your responsibility to keep up with your parents and to keep up with those payments. Thank you.
Thank you.
We'll send that by mail, Maria. We'll do both. Let's just do both.
Yes, please.
Yes, thank you. Thank you, ma'am.
Thank you.
Court calls the cases of the people versus Dion Bird. Thank you. I have a deed.
Good morning. That's the public hearing on behalf of people.
Your name?
Dion Bird.
Mr. Bird, you are before the court on 2 felony complaints. Case ending in 0228. That alleges that on or about August 9th, 2024, location of Superior Township, that you did commit the offense of stalking on an Erica Jemerson Bird. You understand? Actually, aggravated stalking. You understand the nature of that charge, sir?
Yes.
That's a felony punishable by up to 5 years incarceration and $10,000 fine plus court costs. Probation could be ordered for any term of years not less than 5. You understand that, sir?
Yes.
Count 2 on that complaint alleges the offense of malicious telecommunications service involving a domestic relationship. You understand that charge, sir?
Yes.
Misdemeanor punishable by up to 6 months incarceration and $1,000 fine plus court costs. Understand that?
Yes.
On the other case, the case ending in 0229, that alleges that on or about August 10th, 2024, at the location, same location of every township that you did that time, also commit the offense of stalking or aggravated stalking. You understand that charge?
Yes.
Felony, 5 years, $10,000 fine plus court cost. Probation for not less than 5 years. You understand that, sir?
Yes.
The other is also the same charge of malicious use of a telecommunications device involving a domestic relationship. Misdemeanor punishable by up to 6 months, $1,000 fine plus court costs. You understand all of that, sir?
Yes.
First question I have for you is, do you want to be represented by an attorney?
Yes.
This is a public defender case.
Yes, Your Honor. Assistant Public Defender Nicholas Bukovich on behalf of Mr. Bird.
You waive for further formal reading.
Yes, we will wait for the formal reading, be standing mute as to the charges.
And then having waived formal reading, standing mute as to the charges. I'll set a probable cause conference in this matter for
April 30th.
MP. April 23rd, 2026, 9 a.m. Pass the bond.
Your Honor, in this case, is the court to proceed at the bond information form from office?
I believe I am. Yes, I am.
For the record, Your Honor, we're requesting a $50,000 surety bond, as well as a GPS tether with a hot zone of the link. We are with a criminal contact, with the victim. as well as the conditions, including those that firearms and or other weapons, based on the state of Massachusetts offense. During this case, defendant, was texting the victim friendly messages using his mom's phone to tell the victim. Some of the threatening messages included, like, even if see.
Yeah, so I was
Keep walking, you bitch. Gotta learn to keep my name on your mouth. Don't be home. Victim, this is a reauthorization, Your Honor. So initially the cases were dismissed. However, defendant made the decision to continue his harassment of the victim repeatedly. And so here we are again.
Exciting and new.
This time the case is not just going to disappear. So with all type honor, that is our.
Your Honor, at this time, I would be requesting a personal contents bond on my client's behalf, as indicated by APA Tanha. This is a reauthorization. These cases were already litigated. He is here purposely availing himself to the court today to handle these matters. He is not running away from these matters, as indicated, he is here standing next to me right now. He does have full-time gainful employment. I do not believe there would be any issue of any no contact or no go to orders. At this time, Your Honor, based upon the fact that my client is here trying to get these matters handled on reauthorized cases, I believe a personal contents bond would be appropriate.
Right. Well, as to the conditions of the defendant's release, I would indicate, first of all, that there is to be no use and or possession of any alcohol, recreational marijuana, or any illegal drug. You understand that, sir?
Yes.
You are not to leave the state of Michigan without permission of the court. I will also indicate that you are not to purchase, possess a firearm, ammunition, dangerous weapon, or anything fashioned to be a weapon. You understand that?
Yes.
You are ordered not to assault, terrorize, frighten, intimidate, threaten, harass, molest, or stalk anyone. You understand that, sir?
Yes.
I will also indicate that you are not to have contact by any means whatsoever with Erica Jimerson Bird. You understand that?
Yes.
And when I say no contact, I mean absolutely no contact except with a civil standby. You shall not attempt to have any direct or indirect contact with that person, either through others or through yourself. You're not to do that with any electronic communication that's including but not limited to phone, email, texting, internet, and you are not to mention that person on social media or on the internet. You understand that, sir?
Yes.
I'm also going to indicate that you are not to go to, do you understand that?
Yes.
Except with a civil standby. You understand that, sir?
Yes.
You are not to violate any criminal law. You are to personally appear at all court proceedings. You understand that these conditions that I've given would apply whether you're in custody or you are released. You understand that, sir?
Yes, sir.
I am going to, for a review of the bond sheet, everything, I am going to set the defendant's bond at about $50,000 as surety on each case. Defendant is ordered remanded. If defendant is released, he's to be placed upon a home confinement GPS tether. Thank you.
In the matter of the state of Michigan versus or just Shahaj, 26419. Appearance for the people, please.
Good morning, Your Honor. Max Beisel, P77513 on behalf of the people.
Mr. Mays. Mr. Mays, your appearance, please. All right, we're gonna have to recall this matter. He might be in another court. So we will recall this matter. All right, let's go off the record for a moment. We don't have anything else ready, I don't think, right? Okay. All right, we are on the record in the matter of the state of Michigan versus Shahaj Orjas, 26419. Appearance for the people, please.
Good morning, Your Honor. Max Beisel, P77513 on behalf of the people.
And for the defense?
Good morning, Your Honor. William Mays on behalf of Mr. Sheep.
Counsel, you're not coming through.
William Mays on behalf of Mr. Sheeha, Your Honor.
All right. And so there's a couple things happening today. First of all, Mr. Sheeha, is it Sheeha or Shaha? Sheeha. Okay. Mr. Sheeha is in his vehicle, which I understand he's in the parking lot. So
correct.
I'll address that in just one moment. So this court will note that today is the date scheduled for the arraignment, that Mr. Mays filed a motion late in the day on Thursday, April 2nd, regarding a waiver of arraignment. The court was closed on Friday, April 3rd, and then the court, myself, I was off on Monday, April 6th. There was another motion of the same content filed on Tuesday, April 7th, whereby there was a response after my purview of the motion that had indicated that the court was not going to grant the motion. The court, then Mr. Mays then filed an additional extensive motion, as he stated that he did.
Was she at the Natty too? I'm just curious.
And then also attached to the motions was a request via email that Mr. Mays wanted to go straight to preliminary examination. The court did review the appropriate court rules 6.610D4, as well as the other appropriate court rules, and review of the other legal basis by which Mr. Mays made his motion. The court will note that the waiver of arraignment, and to permit it to be via written waiver and not any appearance, is discretionary by the court. This court will also note that given the timing of the motion, with the limited court days of operation, as well as my schedule, the court also did not have time to review appropriate.
Oh my God. What's with this purple and blue mermaid hair, bottom right? Woo. Oh, I want no part of that.
The file to determine whether the court was going to order any condition precedent to allow the defendant to be arraigned without personally before the court. That is something that the court is permitted to do. The court, given the timing of this, was unable or did not have that ability. The court will also note, given the timing, the date of the offense, and that the defendant needs to be seen on this type of case within 14 days, timing was a significant issue as it relates to the timing of the motion being filed. Further, as far as any waiver of preliminary examination, that does need to be stipulated. The state has a right to have a preliminary examination, as well as the defendant. And without having anything in writing from the state, the court is not waiving, both the state and the defense have a right to have a probable cause conference. There was not anything produced in writing that would suggest that the state was waiving their right to a probable cause conference, so the court's denying the request to go right to preliminary examination. Further, in reviewing Mr. Mays's motion, the court does not have the required information that it needs to be able to make a determination regarding any pretrial release factors for Mr. Shahid. So as such, the court is exercising its discretion in denying the request to waive the arraignment via mail, and the court is proceeding with the arraignment in person. Further, there is a request for the court to determine a schedule conflict policy, or to contact the courts that Mr. Mays indicated he had conflicts with. the court does not find that that's something this court needs to do, as the court did permit Mr. Mays to appear via Zoom based upon his tight schedule that he had this morning. The court also indicated that and that was communicated as well by way of staff, that Mr. Shah was to be in person. So Mr. Shah is to appear in person in the courtroom. Counsel, you will be present via Zoom, just as if you were here in person. So, Mr. Shah, you need to make your way into the courtroom.
Oh, Judge, you just spoke, I don't know for how many minutes.
Excuse me?
You're not even going to ask me for a response?
Counsel, I've made my ruling. Counsel,
I'm sorry?
I've made my ruling. I've denied the motion, and I'm requiring that your client be present for the arraignment. And I'm not granting your motion to waive the arraignment as far as only doing it via mail or via writing.
I'm sorry, what? We're going to do it by mail?
No, counsel, I denied the request to to have you waive the arraignment in writing.
Well, fortunately,
as I stated, it's the court has discretion to grant that. And further, the court does not have the ability to make a determination for any pretrial release factors in the way that you have requested the arraignment be done. And given the nature of the charges, the court needs to go through those factors. Further, the court will also note, counsel, that you stated that there are 3 charges for your client. The court has 2 charges, counsel. I understand that the information. I understand that the information sheet that you've attached has 2. However, the complaint that I'm looking at, I'm sorry, what you attached has 3. The complaint that I'm looking at has 2 counts for your client. So that's the other reason this court indicated it was going to be not done.
Not a problem, Judge, but fortunately, because our 9:45 arraignment time, it's now 11:10. I'm done in Lincoln Park. You're very close. So I'm going to let you go, Judge, because I don't want my client to be there in person while I'm on Zoom. I will come down to the court. I've just completed my morning docket. I will see you in a few minutes if that's acceptable.
So, Mr. Mays, the court will first state that, yes, this was scheduled for 9:45. There were some technical difficulties that delayed us by about half an hour because our entire recording system shut down and we needed to have the assistance of IT. So, based upon that timing, and if it still works for your schedule to get to the other side of the state timely, then yes, you can make your way on into court. No problem.
Thank you, Judge. I'll see you in a few minutes.
All right. See you shortly.
Your Honor, should I also get off the Zoom call as well?
Yes. Yep. And you can just either wait in the parking lot for your attorney or in the lobby, whichever you prefer.
Okay, thank you.
You're welcome. All right. Thank you. All right. And so then we will go on the record and we will recall the matter of the State of Michigan versus Orjas Shiha 26419. And I'm sorry if I've mispronounced that last name.
Thank you very much, Your Honor. Good morning. William Mays on behalf of Mr. Shiha. Sir, come on up. State your name for the record, please. Orjas Shiha.
Hi. Okay. I'm just writing it down phonetically. Okay. All right. And so thank you for dressing appropriately for court. And counsel asks the arraignment.
Judge, you've not allowed me to waive it.
I've not allowed you to waive it in writing.
I literally wrote it, and just to correct the record from before, I did not file a motion until I received communication from your court clerk indicating that the explicit, I don't know how many pages it was, 4 pages, signed by both of us. There was an appearance filed well over a week ago that waived the arraignment. Then there was an explicit advice of rights form that was signed by my client, plus all the information contained in the information, which I understand the court is saying that he's not charged with malicious destruction of police property but the information does state that he is charged with malicious destruction of police property. So all of these charges are contained in that written, explicit waiver of arraignment. Then I communicated with the court indicating, here's these documents, can we waive the arraignment? It was only after that, on Tuesday evening, I believe. Yes, Tuesday evening, that the court clerk indicated that no, none of this was acceptable. That's when I filed my motion and my brief.
Okay.
My motion and my brief go explicitly through all of the court rules.
Just one moment. So I will correct the record in that you did not file a motion on April 2nd. It was a waiver of arraignment that you filed on April 2nd. All the other portions of the record is what the court indicated as far as procedurally. So let me just state this, counsel, that I'm looking at a complaint that states that your client, there's 3 counts on the complaint. Your client is charged with 2 of them, not malicious destruction of fire or police property. I don't know what the information, I don't know why that's different from the complaint, but I'm just letting you know that the court documents that we have indicate that your client's only charged with 2 of the 3 counts that is on the document.
Yeah, understood.
So
now the prosecutor should be on Zoom right now.
Just one moment. So because there is that discrepancy, in addition to this court wanting to have the opportunity and the ability to determine what the pretrial release factors, that's why this court did not grant the waiver of arraignment in writing. And I've already stated that. So, Mr. Beisel, if you'd like to state for the record why the information shows that Mr. Shahai, I apologize, has 3 counts on the information, but only 2 on the complaint.
Good morning again, Judge. It was just a typo. I provided defense counsel the complaint, the warrant, as well as the information reflecting only 2 of the counts for his clients, counts 1 and count 3.
So, Judge,
okay.
The thing is that in reference to this court's declaration that it can't properly assess pretrial release conditions under MCR 6.106, I mean, that was addressed in my motion. You can at any time. You have the co-defendant on Zoom with his attorney on Zoom. I mean, we have provided the court everything consistent with Phillips.
Mr. Mays, I cannot question or ask information about employment or failure to appear history, any pending. I can't ask that information to a piece of paper. Okay.
I understand.
So I can ask you, I can ask your client, whatever that may be, but I can't do it to a piece of paper, which is why this court did not grant your request to conduct the waiver, to conduct the arraignment via writing. Okay.
Understood, Judge.
So that is, and I've already stated that.
But I'm just curious as to why it is.
Excuse me. Further, in your email, you wanted to go right to preliminary examination. But according to the court rule, the state also has the right to have a probable cause conference, and there wasn't anything that was put forth in writing that stated that both parties were explicitly waiving that probable cause conference. So that's why the court was not going right to preliminary examination. Third, the co-defendant and his attorney are on Zoom because the court does allow probable cause conference purposes parties to appear via Zoom, the attorney and the defendant, so long as there hasn't been any issues that would prevent that from happening. And in your case, that has not occurred. There are some attorneys that have lost the opportunity to appear via Zoom because of their continued delays, we're thereby having issues with the Wayne County Jail camera. So all that being said, as to the arraignment for your client, because there's been a confusion, do you want me to go through and do a formal reading for counts 1 and 3, or do you want to waive the formal reading and we can continue with that?
Judge, we've done everything in our power to waive the reading.
Counsel.
I don't know what else I can do to waive the reading. What would you like me to
stated a waiver of
arraignment?
Counsel, you indicated a waiver of arraignment, a whole waiver of the arraignment, and going right to preliminary examination.
Yes, that was the first document.
And yes, and not appearing in person. So now you're here in court. So
Just say yes. We waived the reading, jackass. I think that's pretty clear.
My question is this: do you want me to do a formal reading of the charges, or because there's counts 1 and 2 only, and you've waived counts 1, 2, and 3, or do you want me to waive the formal reading of counts 1 and 3 and proceed with the next steps?
Judge, I'm just going to reiterate from my motion and my brief.
Okay,
That
never mind.
criminal rules.
Contempt, right there. Contempt. He's not that stupid. He's in his feelings and he's just being a complete jackass for no reason. Contempt. Now.
No, we don't need.
Not make it more difficult.
No, that's fine. I'll go through a full.
Judge, I'm asking that I be allowed an opportunity to be heard.
Counsel, you've been heard.
No.
Yes, you have. The court's going to state that the court does have before it a complaint that alleges that on March 29th of 2026 in the city of Wyandotte, that it's alleged that your client did on count 1, assault, batter, resist, obstruct a police officer or first responder, where it's alleged that your client did assault, batter, wound, resist, obstruct, oppose, or endanger Shane O'Meara and Jonathan Cox, a police officer of the Wyandotte Police Department, who the defendant knew or had reason to know was performing his or her duties contrary to MCL 750.81D paren 1. This is a felony charge. The maximum penalty upon conviction is not more than 2 years in the state prison and or a $2,000 fine. A consecutive sentence may be imposed under MCL 750.506A if the assault was committed in a.
I would ask for contempt if I was the prosecutor. I really would. I would wait until it's my turn, and then I would say, I've got a life to lead and a pile of files, and I don't need this in my life. Counsel is absolutely disrespectful to the court and thereby me as an officer of the court. Get it done, Judge.
Place of confinement or under MCL 750.81D paren 6 for another violation arising from the same transaction. Your client's also charged with operating while intoxicated, where it's alleged on the same date and location your client did operate a vehicle upon a highway, Fort Street, while having an alcohol content of 0.08 grams or more per 100 milliliters of blood, contrary to MCL 257.625 paren 1. This is a misdemeanor charge. The maximum penalty upon conviction is not more than 93 days in jail and or a $100 to $500 fine and or 360 hours of community service, rehabilitative programs, vehicle mobilization with a prior conviction, cost of prosecution, reimburse government for emergency response, and expenses for prosecuting defendant. Counsel, as to the plea, is your client entering a not guilty plea?
Oh, absolutely. Judge can kick an attorney out, but they need some basis. I mean, if you were in there and being respectful and doing your job and they just said, oh, get the hell out of this courtroom, they've got a problem. They're supposed to be a neutral arbiter of the situation, and you're talking to an officer of the court. But if someone's being a jackass and it's on the record, then it's open season.
For the fourth time, he is entering a not guilty.
So that's yes, not guilty plea.
I would have rung this guy up long ago. Absolutely rung him up.
All right, so you do have the right to have an attorney. If you're unable to afford one, you may have one appointed to represent you. And in this matter, you've exercised your right to retain your own counsel, correct?
Correct.
You also have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have a trial by a judge or by a jury.
Yes, that and many other reasons. But even before that is I don't want to do it and the pay sucks.
You also have the right to remain silent. Anything you say orally or in writing may be used against you in court. Do you understand those rights, sir?
Yes, Your Honor.
All right. The court's entering a plea of not guilty on your behalf, scheduling this matter for probable cause conference on.
We've got the prosecutor on Zoom, Judge. I think that they're willing to waive the PCC. Is that right?
Counsel, I'm really I'm really done being continuously interrupted. So as I was getting ready to say, we are going to schedule this matter for probable cause conference on April 16th, unless there is an agreement by the prosecution to waive the probable cause conference, or if there is an agreement in a waiver of time standards by you and your client on the record. So, Mr. Beisel, what is it? Are you wanting to exercise, is the state wanting to exercise their right to a probable cause conference, or are you in agreement to waive the probable cause conference and go straight to preliminary examination?
If people would have no objection to going straight to preliminary examination, I did speak with defense counsel this morning, and he indicated he wants to hold the exam on that one count of the resisting, obstructing a police officer. So I'd have no objection to just setting that date so we can speed this along.
Thank you.
Okay, so I will, the court will state that probable cause conference waived on the record. All right, is your client also waiving time, counsel?
Yeah, we don't have anything. You've got a right to a preliminary examination that's prompt. We're going to waive that time requirement. So whenever it's convenient for the court and the prosecutor.
And so you
agree to waive that? I agree.
Okay, very good. Thank you. Okay, and so we can set this for April 23rd. Does that work for us, Ellie?
What time?
I'm going to get to that, counsel.
We can do 11 a.m.
Okay, does that date and time work?
Morning's booked, afternoon's open.
Okay. Can we do the afternoon that day?
Yes, we can do 1:30.
Perfect.
All right, Mr. Beisel, does that date and time work for you as well?
That does, Judge. I was going to say mostly that 20th through the May 1st, I'm in a 2-week homicide trial, but we are ending at noon on that Thursday, so I can come at 1:30 to hold the exam.
All right. Any witness and exhibit list by April 20th? And then ask to bond counsel.
Judge, he is fully gainfully employed at Ford Motor Company, a lifetime resident of Southgate, Michigan. The only thing I've seen prior to this is one prior misdemeanor, if I'm not mistaken. No history of non-appearance, no history of flight, voluntarily turned himself in on this complaint. I would ask for personal recognizance.
All right. And so, counsel, the prior misdemeanor you're referring to, is that from Lenawee County?
I think so.
Okay. The disorderly intox. Okay. And sir, do you have any prescription medications that you're prescribed on a regular basis?
Yes, Your Honor.
Do you take those in accordance with your prescriptions?
Yes.
Have you consumed any alcohol since the date of this offense?
No.
Who do you reside with at your home, sir?
His parents.
Do you have any other pending matters? I'm sorry?
No, Your Honor.
I don't see that there's any failure to appear history. All right, the court's going to order a $10,000 personal bond with the following bond conditions. You're not to possess or consume any alcohol or drugs unless prescribed. And then just have a seat, counsel, and or if you want to head out, you can to get to where you go. You can. You're fine. Just need a copy of his bond conditions.
Very good. Thank you very much.
See you back on April 23rd.
We'll do it.
Have a good
Thank you,
day.
Judge.
Thank you. Have a good day.
Oh, good Lord. That was out there. I can't believe the way that guy was behaving. I really can't. That was crazy stuff. Fantastic stream, though. Fantastic stuff. Thank you, Zach over at Law Nerds Unite, and Alyssa. Who got me some stuff in real time. That then I had to stream off the live, which was fine. It was cool. Thank you all for coming out. No, I'm not going to be a judge. It's not going to happen. I don't want to do it. They don't want me to do it. Everyone agrees this is a bad idea. All right. I will see you all soon.